look at you and it's easy to see you are that someone I've been trying to meet. I got your number, won't you pick up the phone? Don't leave me hanging on the
Hello everyone, welcome back to my YouTube channel Legal World. Myself Dr. Seema Goyal. Today in this video I am going to discuss question relating to the Indian judicial system. My question is, define the Indian judicial system as well as its characteristics. Or this question may be asked in another form, that is, define the independence of judiciary as well as various provisions which are provided by the law. Talk about the Indian polity, that is divided into three parts, that is legislative, executive as well as judiciary. Our judiciary is independent in itself. An Indian judicial system, which is one of the oldest one in the universe, plays an important role in the protecting the interest of the citizens by providing the platform for speedy trial to them. In our Indian judicial system, highest court, that is the Honorable Apex Court, that is Supreme Court, who is the custodian of this constitution. If we talk about the various characteristics of the Indian judicial system, there are various characteristics. One of the characteristics, that is the one of the oldest one in the universe. As I have told, Indian judicial system is one of the prominent judicial system, that is oldest one in the universe. And the doctrine of separation of power provides independence to our judiciary to interpret the laws according to them. And judiciary doesn't make any statutory laws, but interprets and applies laws in the country. And the second characteristic, that is the unique judicial system. In India, there is unique judicial system. Supreme Court, that is on the top, which is the highest court in India. That is the superior court. If we talk about the third characteristic, that is the independence of judiciary. In the 18th century, the concept of independence of judiciary was introduced in India for the first time, when the doctrine of separation of power was formulated in the political and legal field. And the independence and the competent judiciary, that is essential for safeguarding our civil liberties in a democratic state like India. The doctrine of separation of power, which was pronounced by Montesquieu, insisted on exercising the power of the government by these three separate organs. These organs are executive, legislative as well as judiciary. An independent judiciary plays an important and vital role in controlling the power of the executive and legislative. Only an independent judiciary is able to protect the rights of the minorities and indigenous communities. Independence of judiciary maintains the supremacy of the constitution by ensuring the rule of law in a country. Thus, we talk about the basic components of the independence of judiciary. And independence of judiciary requires the certain essential elements or the components. The first element, that is the adequate constitution and legal provisions to insulate the judges from the legal pressure and influence from the non-judicial authorities. And second element, that is the adequate physical infrastructure for discharge of judicial functions. Third is well-educated and well-trained judges. Fourth, well-trained and competent court staff. And the fifth one is secure as well as adequate resources for the court administration and proper mechanism for ensuring the accountability of the judges. These were the certain essential elements that constitutes the independence of judiciary and which can be seen in our Indian judicial system. If we talk about the independence of judiciary in India, our Indian judicial system must have independent and impartial structure. Here the term independence means that the other two branches of the government, that is legislature and executive, does not interfere with the working of the Indian judicial system. Two organs must respect the decisions made by the judiciary in India. And the judges in India are able to perform their functions without any intervention of other two organs, that is legislature and executive, without favoring anyone. So we can say that our Indian judicial system is one of the independent judicial system. Even though the judiciary in India is independent, its structure is not arbitrary. So it is accountable body. And the judiciary is answerable to our constitution and its people also. If we talk about the basic provisions which are given by the law for the protection of the independence of judiciary, there are the certain provisions which are provided by the law for the protection of our Indian judicial system. First element, that is legal authority. Our Constitution of India guarantees the independence of judiciary by providing the separation of power among the three organs, that is legislature, executive and judiciary. Thus our judiciary is free from any improper and unwarranted interference of other two organs, that is legislature and executive. It is a fact that the quality of justice depends upon the independence of judiciary. For this purpose, the court should be allowed to perform its functions independently, and it must be free from political pressure. Thus, founding father of our Indian Constitution added the Part 4 in the form of DPSP, Directive Principles of State Policy, which directs the state to make all efforts to keep the judiciary free from politics. And the Constitution of India has enshrined many provisions in order to ensure the independence of judiciary. And these provisions are: number one, judicial appointment. Independence and impartial judiciary is the essential element for democratic government. And the independence of judiciary starts from the appointment of judges. Article 124 of the Constitution deals with the appointment of judges of the Supreme Court, and Article 217 deals with the appointment of the judges of the High Court. And Article 124 to 147, which is given in Chapter 4, deals with the establishment and constitution of the Supreme Court and appointment of judges and their powers. While the Article 214 to 231 deals with the constitution of jurisdiction and appointment of judges of the High Court, his powers, rights, etc. Thus, the judges of High Court and Supreme Court are appointed by the President. If we talk about the salaries and allowances, the salaries and allowances of the judges is also factor that makes the judges independent. And the salaries and allowances of the Supreme Court judges are charged on the Consolidated Fund of India, while the Consolidated Fund of State in case of High Court judges. If we talk about the next element provided by our linear legal system, that is the removal of judges. In India, both the Supreme Court and High Court judges are appointed by the President. That is, provisions are provided by Article 124 to 147 and can be removed under Article 124 Clause 4 and 217 on proved misbehavior or incapacity after the impeachment motion, which is passed by each house of the parliament by majority. In India, judges can be removed from his office by his president. If we talk about the transfer of judges, as per Article 222, the president has power to transfer the judges from one high court to the other high court. And the president can transfer a judge only after consultation with the Chief Justice of India. Thus, the power to transfer the judges is not absolute. He can do so after consideration of two things, that is public interest and effective consultation with the Chief Justice of India. If we talk about the power to punish for its contempt, for independence of judiciary, it is essential that everybody should obey the judgment which is passed by Indian court. For this purpose, Article 124 of the Constitution says that the Supreme Court shall be a court of record, which means Supreme Court has power to punish for its contempt. And Article 215 grants a similar status to the High Court also. About the provision of the practice after retirement, our Constitution debars the judges of the Supreme Court and High Court from pleading or appearing before any court or tribunal or the judicial authority in India after the retirement. However, a High Court judge can after retirement practice in the Supreme Court or High Court in which he had not been a judge under Article 220 of the Constitution. But under Article 124 Clause 7, a Supreme Court judge can be a member of the Parliament. And the next element, that is the condition of service. Here the condition of service means those terms and conditions within which a judge has to act during or after the service as a judge. It has direct effect on the independence of judiciary. For this purpose, the Supreme Court judges Condition of Service Act 1958 Amendment Act was passed. And for the High Court judges Condition of the Service Act 1954 as it was amended in 2009, lays down the conditions for the services concerning the leave, pension, allowances, housing facility and gratuity, etc. And the next element, that is the establishment of the court. If we talk about the establishment of the court, that is also essential factor for the independence of judiciary. By establishing court means administration which is set up, or the setup of the court. Our constitution provides provisions for the establishment of the courts, including the appointment of judges in high court or the supreme court. It may be judges in the lower court also. Thus the salaries which are paid from the fund of India to the supreme court judges, and the provisions for the Indian constitution provides for the effective and full control of the chief justice over the administrative staff of the court. Thus we can conclude that the independence of judiciary, that is the basic feature of our Indian constitution, which is prerequisite for the smooth functioning of the constitution and for realization of the democracy which is based on the rule of law. So it's all about the Indian judicial system as well as its independence. If you like my video, then don't forget to like, share and subscribe this channel for the further update. Thank you.
Baby, read the fine print.